A case recently argued before the Supreme Court asked the question, what is a taking under the Fifth Amendment to the Constitution? This is not a simple case of eminent domain, but the power of the state to take control of private property. And since this case comes out of California, you shouldn't be surprised that it's a tangled mess that brought it to the Supreme Court. But the opinion in this case will impact more than just California residents, since it could be used as justification for both state and federal governments to deprive you of your property rights and give them to a favored voting bloc. So we'll discuss that next on the Constitution Study.
You have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Welcome to the Constitution Study. I'm Paul Engel, your host. I'm glad you could join me today. As always, please, if you want more information, head over to the website, constitutionstudy.com. You'll find the articles I'm working on. You'll find news of what's going on at the Constitution Study. You can also listen to me daily at 3 p.m. Central, 4 p.m. Eastern on the America Out Loud radio network. So please get involved, share this information, donate if you can, find out more both at constitutionstudy.com or find out about the site constitutionscholars.com. And with that, let's talk about this property rights case out of California. To understand the issues of this case, we need to recognize two important facts. First, that while a person is free to exercise their rights, that does not include the authority to infringe on the rights of another. Second, property is not simply the land or goods you own. It is anything you own or have control over. Webster's defined property in his 1828 dictionary as the exclusive right of possessing, enjoying, and disposing of a thing. Ownership. The question posed to the court was, when a state grants an easement, a right of use over property of another, is that a taking under the Fifth Amendment? Quote, California law forces agricultural businesses to allow labor organizers onto their property 3 times a day for 120 days each year. The regulation provides no mechanism for compensation. A divided panel below held that although the regulation takes an uncompensated easement, it does not affect a physical taking of private property because it does not allow 24 hours a day, 365 days a year occupation. Now, the law in question is California Code of Regulations, Title 8, Sections 20,900E. Quote, accordingly, the board will consider the rights of employees under Labor Code Section 1152 to include the right of access by union organizers to the premises of an agricultural employer for the purpose of meeting and talking with employees and soliciting their support. Not surprisingly, the Ninth Circuit Court of Appeals states that the granting of this easement is not a taking since it does not allow full-time access for the union officials. Now, this position is patently ridiculous. I would ask the justices who concurred with this opinion how they would react if I were to take their car 3 times a day, 120 days a year without their permission. Would that not be considered theft? Then how can the state of California grant an easement without the owner's permission and not consider that a taking of their property? This case is not a Fifth Amendment taking, but not for the reason the Ninth Circuit stated. See, the reason this is not a Fifth Amendment takings clause is because the property wasn't taken for public use. From the Fifth Amendment to the Constitution, quote, nor shall private property be taken for public use without just compensation. The California regulation does not take the property for the use of the public, at least not as Noah Webster defined public, as open for general entertainment as a public use, open to common use as a public road. What California has done is worse than eminent domain. They are not taking property for public use. They have stolen the property of agricultural businesses for private use. They have granted private organizations, in this case unions, access to private property without the owner's permission. By any just legal system, the business owners should be able to charge union organizers who come onto their property against their will with trespassing, just like anyone else. But if this law isn't a violation of the takings clause, does that mean it's constitutional? Not even close. Sadly, for all of the lawyers who were involved in this case, they couldn't see the regulation is an obvious violation of the Fifth Amendment's due process protection. Just before the takings clause in the Fifth Amendment is its due process clause, quote, nor be deprived of life, liberty, or property without due process of law. What California is doing is not taking property for public use. They are clearly depriving the business owners of the exclusive right of enjoying and disposing of their property, and they are doing so without due process, which is defined as an established courts for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. Since this is being done by a state, it not only violates the Fifth Amendment to the Constitution, but violates the 14th as well, which states, quote, "Nor shall any state deprive any person of life, liberty, or property without due process of law." What saddens me is that the plaintiffs, as well as the agricultural businesses in California, may be denied justice, not because their cause is not just, but because the lawyers need a remedial reading class. It seems law schools are educating their students into imbecility, and the American people are paying the price. Even if there were a justifiable case of this law being a taking under the Fifth Amendment, it would not compensate the businesses for the damages done to them. If this were a taking, what would be just compensation? Would the owner be paid the market price for the land that these union organizers are occupying? Would it be prorated based on the amount of time the union occupied it? And what about the lost time of the business's employees, the ones that the business owners are paying for? Now that's being disrupted by the union. Would that be part of the compensation? How would someone go about calculating that? And if this were a taking, it would not be the union who would have to pay the business owners, but the people of California through their taxes. Meaning the people of California, including the business owners who are having their property stolen, would be paying for the right of private organizations to disrupt the businesses of others. And not just for past infringements, but future ones as well. And if that isn't a twisted view of a public taking, I don't know what is. This would not be the first time courts have used government's taking power to steal private property from one person to give it to a private group. The Supreme Court did exactly the same thing in 2004 with the Kelo versus City of New London case. In that case, they found that the City of New London could use eminent domain to take property from Suzette Kelo for a fraction of its market value in order to give it to the New London Development Corporation, a private nonprofit company, which planned to sell the land to Pfizer, Inc. Since the court has previously shown itself more than willing to play a twisted Robin Hood, stealing from one to give to another simply because they are more favored by the government, I'm not sure what this court will do. On the other hand, if the court would consider this not a takings case, but a deprivation of property, not only would the plaintiffs be on firmer legal ground, but the remedies available to the court would be more just. Since the case is against the chair of the Agricultural Labor Relations Board, there is no way for the court to grant compensation from the unions for the damages they have done. That'll have to be paid by the taxpayers of the state of California. However, since Victoria Hasid, as the chair of the Agricultural Labor Relations Board, has violated the rights of the agricultural business owners of California under color of law, she could not only face civil, but criminal charges. See, 18 U.S.C. 242 reads, "Whoever under color of any law, statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien or by reason of his color or race, than are prescribed for the punishment of citizens shall be fined under this title or imprisoned not more than 1 year, or both." See, rather than simply having the people of California pay for the damages done under this odious and tyrannical regulation, I would like to see those who created and enforced it punished personally for their dereliction of duty and violation of their oaths of office. Until elected officials and bureaucrats are held personally accountable for their actions, there is no incentive for them to obey the laws and exercise only the just powers of the consent of the governed. Sadly, as much as I would like to see the agricultural businesses of California freed from this regulation, this case does not give the court a judicially cognizable reason to do so. I hope that one day, not only the bureaucrats in California, but the people who allow them to keep working are made to pay for the damages they have done to their citizens. So this appears to be another case where lawyers, who apparently either have not read the Constitution or are incapable of understanding its simple language, have brought a case where the people have a just grievance that needs redress, But because of the way they've bring in the case, that what they're actually charging, they may not get it. The businesses in California may not get justice, not because they don't have a claim, but because their lawyers screwed up. Just one other reason why we can't trust either that the law schools are teaching the Constitution or that our lawyers know what the Constitution is, much less would recognize if it bit them in the backside. It's one more reason why we, the people, need to understand our rights. Not only to recognize the violation that the Agricultural Labor Relations Board of California is committing, but so that we can assist in our own defense. So we can tell the lawyers, no, this is not a takings because it's not public use. This is a deprivation of property. That means it's not only a civil violation, it's a criminal one. But since we can't be bothered to read the Constitution, we're not prepared to help in our own defense. We leave it to so-called experts who apparently can't read, or at least not comprehend. This is so frustrating, not simply because of the tyranny that is California. I've come to expect it out of California, as well as I've come to expect ridiculous opinions coming out of the Ninth Circuit. No, what really aggravates me is that a group of citizens that are being abused by their state government have had their day in court and may not win because their lawyers are incompetent. That sounds like strong words, but what else would you call it when they can't recognize that allowing access to the union is not public use? The law specifically states the access is only for certain private organizations. And until we start holding them accountable, and I mean legally accountable, until these bureaucrats and politicians start feeling the pain of the consequences of their decision, they'll keep making them. Do you want to know why people are leaving California? Nonsense like this. I only pray they don't bring it with them. So do me a favor, head over to the website, constitutionstudy.com, find out more, find this article, find the video, share it. If you know people in California, especially in the agricultural business, share it with them. It may not help the case in front of the court today, but it may give them grounds for a better case tomorrow. In any case, share this so the people understand that their rights are being taken and the people they're trusting to protect them, in many cases, are failing. If you have a good lawyer, great. But you need to be prepared to deal with the fact that you might not have a good lawyer. How do you tell the difference? Also, do me a favor, head over to the site constitutionscholars.com. Yes, you can go to the library, you can read, you can watch the videos. They're all free. It's a free sign up. But join your state group. Be involved in your state, not just a California group, unless, of course, you live in California. Be involved with your state group. See what's coming down the pike. I'm posting links to articles every day about what's going on in the different states I think are related either directly or indirectly to constitutional issues of that state. You can find out more. And again, you sign up. It's absolutely free. And if you like that, share that as well. Find others in your state that are interested in protecting your rights and liberties. Encourage them to watch these videos, listen to the podcast. Heck, go to AmericaOutloud.com. You can listen to me 5 days a week. I'm on for an hour a day talking about issues like this. And if you found that useful, if you found this worth sharing, I hope you'll come back. And we'll talk again the next time on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from